Just bear with me, please. It's just loading up. And I would now need to minimize the screen before I can read. Oh. Okay. Okay, Councillor Kelly.
We're live.
Yeah.
Good morning. My name's Councillor Kelly. Thank you very much for your patience while we were ironing out some IT issues. My colleague Cornelia Harding from Democratic Services is going to read out just the chairman's introductory statement on my behalf. Ms. Harding?
Yes, good morning, everyone. My name is Cornelia Harding, and I'm introducing Councillor Kelly. Oh, excuse me. I could hear myself.
Yeah, it's very hard. It's very hard when that happens. It's almost impossible.
I'm not quite sure how to.
Just maybe take the yeah.
Yes, but I could hear what was just said. I'm just going to close that window. Okay, I'm introducing Councillor Kelly, Councillor M. Ahmed, and Councillor Summer, who today comprise of today's subcommittee. Hatun Zeb is the legal advisor to the subcommittee. Myself, Cornelia Harding, is the clerk to the subcommittee, and I'll be minuting the meeting. Cheryl McLean, who is also a member of the Democratic Services team, is also present. In accordance with procedure, the chair, Councillor Kelly, will invite the police as the responsible authority to present the application for a review hearing and to call on any witnesses in respect of whom permission to appear has been given, and to answer any questions put to them. Thereafter, Councillor Kelly will invite the premises to make their representations and answer any questions, following which Councillor Kelly will invite the parties to briefly sum up their respective cases. At the end of the hearing, the subcommittee, accompanied by the legal advisor and the committee clerk, will retire to consider its decision. The decision will be given at the end of the meeting today and confirmed in writing within 5 working days. Thank you.
Thank you. Couldn't have said it better myself. So if just quickly obviously I've done this briefly, but just for transparency, because this has been broadcasted, could I have sort of the police team introduce themselves? Mr. Holland, I believe.
Yes, good morning, Chair. My name's Charles Holland and I'm the barrister for the police.
And PC Brown?
Good morning, I'm PC Penny Brown. I'm from the Metropolitan Police Licensing Team. Thank you.
PC Smart?
Good morning, Chair. PC Kerry Smart from the Police Licensing Team.
And we have PC Butler on the call as well, is that correct?
Yes, good morning, Chair. Police Licensing Officer for West Area. Thank you.
Okay, thank you, sir. And for Affilium, Tudor Rose?
Yes, I'm David Dadds on behalf of the premise license holder, and I have Mrs. Cook virtually sat next to me.
Thank you, that's very useful. So if we could go to the police team to present, please.
Well, good morning, Chair. If I can just start, given that we're all virtual, with a bit of housekeeping, just to check we've all got the same documents. I have a set of agenda papers which I've downloaded from the local authority's website, and that's a 92-page paginated document.
bear with me, there's a bit of echoing. Can I just ask anybody, unless they're speaking, to mute their microphones, including myself?
Now, Chair, is that any better? Yes, thumbs up for better. Marvellous. Chair, just to continue with the housekeeping, I've got a 92-page agenda document that I've downloaded from from the authority website. It's very helpfully paginated. I served some written submissions on Friday, dated that day, Friday the 13th of November, 16 pages. I hope you and your colleagues all have that and have had an opportunity to read that. Those crossed with submissions in writing from Mr. Dadds, the 54 paragraphs over 21 pages, with a appendix, which was some extracts from a piece of Home Office guidance running over for 3 pages. And I'm also going to refer to the decision you made when the matter was last before you on the 23rd of October, and that's a couple of pages long. Chair, have you and your colleagues got all those? I can't hear you, Chair.
Yes, we have.
Yeah, we had a pre-meeting and we confirmed that we all have those documents. Thank you.
Well, Chair, I'm just going to set out for you what has happened since we were here the last time, and then I'm going to ask for some direction as to how you want to proceed this morning, because this isn't the first time this application has been before this committee with these councillors. The matter was before you last on the 23rd of October 2020 to consider interim steps. And on that occasion, this committee imposed the interim step of suspending the licence until today, until the full review hearing. And that was on the basis in your written decision that you had no confidence that were the premises to trade further, further breaches would not occur in the meantime. The only things that there are only a few things that have happened since then. Firstly, as we all know, the national lockdown came into force on the 5th of November, and that is the current situation until the 2nd of December at the earliest. Secondly, there had been requests that the premises provide CCTV footage. It's a condition on its license that it complies with those requests. Those requests have been repeated. They'd been made before the 23rd of October 2020 and not complied with. They have been repeated and they have still not been complied with. And indeed, I repeated the request in my written submissions served on Friday, and the opportunity of the weekend to provide the footage has not been taken. Thirdly, the day before the interim steps hearing on the 23rd of October, the solicitor for the premises, solicitor counsel for the premises, had sent a pre-action protocol letter threatening a judicial review of the certificate signed by the superintendent, which is essentially the springboard for bringing an expedited review. A replacement, the police responded to that pre-action protocol letter and didn't get an acknowledgement of its response. A replacement pre-action protocol letter was sent last week. It isn't clear on my reading whether that is merely a repetition of the attack on the certificate or an expansion of the attack to include not just the certificate, but secondly, this licensing authority's acceptance of jurisdiction, and indeed the Secretary of State's making of the regulations which the police say were breached. There have then been, the only other thing that has happened, which I've already mentioned, is the exchange of skeleton arguments, or the exchange of written submissions that happened on Friday. There has been the 21 pages of submissions from Mr. Dadds. Essentially, I hope I don't do them any disservice, appear to repeat and expand upon the attack on jurisdiction that formed the subject of the first pre-action protocol letter, forms the subject of the second pre-action protocol letter. The short answer to that point today is that once a certificate is given, the licensing authority is obliged to conduct the summary view, even if it considers that the information available to the officer when she gave the certificate did not establish that the premises were associated with serious crime or serious disorder. Now, what this committee in fact found that it was associated with serious crime or serious disorder, but what the law is even if you are wrong about that, and even if the superintendent was wrong about that, the place to deal with all of this is in the administrative court on a judicial review, and not in front of the licensing subcommittee of Ealing Council. And I don't know, but it appears that there's an attack on Mr. Hancock's making of these regulations that I don't know if Mr. Dadds is going to invite you to deal with, but the short and simple point is the regulations stand until they're set aside by a court of competent jurisdiction, and you are not a court, and even if you were a court, you don't have jurisdiction to deal with that. But what is quite noteworthy, Chair, in this case is no evidence has been submitted by the respondent. There's no explanation been provided in evidence or indeed in submissions as to why the venue lost control on 2 occasions and committed the breaches that the police assert occurred. There's no management plan at all been provided as to what the premise is going to do going forward. There's no risk assessment been provided for anybody to consider. There isn't any evidence at all, and there are essentially legal submissions put in and nothing else. Now, Chair, I'm in your hands. You have heard already and the evidence in this case and read the evidence in this case. It seems to me that given that none of that appears to be challenged by Mr. Dadds, it's rather a waste of everybody's time to have to do it again, but I will happily, if what you wish is open the case and go through the written submissions again. But essentially nothing other than the things I have just identified: lockdown coming into place, premises still not complying with the request for CCTV, more legal submissions attacking the jurisdiction that I say are legally irrelevant here. Apart from that, there have been no supporting representations put in. Apart from that, we're dealing with the identical situation we dealt with last time, and you've already decided on those facts that you have no confidence that if these premises are to trade, further breaches would occur. So no surprises for what the police submission is that given that for whatever reason, the respondent has decided not to engage at all on the facts of this matter, we are nowhere further forward than we were on the 23rd of October. The position then was the only guarantee we can have that these breaches aren't going to occur is to suspend. The submission this morning is the same, except replace suspend with revoke. So, Chair, I'm in your hands, but that is it in a nutshell where we are today. I can't, Chair, you're going to need to unmute yourself.
Just to confirm, just what you said in a nutshell, your submission to the panel is what? And then I'll let Mr. Dadds respond.
My submission to the panel is that unless you wish me to go over the same ground I went over on the 23rd, I need say no more in making this application. That in effect, the evidence is before you in paper. The evidence in any event is not being challenged by Mr. Dadds. Mr. Dadds has a legal submission which he can make and I will respond to. But the question essentially I have for you and your colleagues is, would you like me to go through the facts again, or can we move on to what Mr. Dadds has to say at the law? Because as I understand it, and I may be corrected by Mr. Dadds, he doesn't want to challenge any of the police evidence. He doesn't want to call any evidence himself. He essentially wants to make some legal submissions.
Okay, thank you very much. So, Mr. Dadds.
Well, what an extraordinary statement this morning by Mr. Holland. Extraordinary insofar as he has assumed wrongly that the hearing, the interim steps hearing, is in effect the full hearing. Of course, it's a matter for him to decide how he wishes to proceed this morning on how he calls his evidence. I agree with him largely. You've got benefit of written submissions from both parties, and you've had the papers and you've heard submissions in the past in relation to an interim steps hearing. But today is the full hearing. An interim steps hearing, I would not and not normally challenge the evidence fully, because that's what we do at the full hearing. He doesn't know what I'm going to submit when I get the opportunity to respond to the police's case. He is wrong if he is asserting that I can only challenge the police's evidence in advance in writing. I thought that was always the case of this hearing today. In essence, he puts his case forward. It's for him to decide how he wishes to present his case. It's up to you if you accept that or give him some guidance, Mr. Chairman. I make no comment in relation to that. It's a matter for him. But to say, well, it appears then I've accepted all the police evidence because I've not put anything in writing in advance. Well, no, that's what we do for today. So he puts his evidence, you'll call me and you'll hear from me, and you'll hear then at that time how I wish to respond to the information which has been presented.
Okay.
Chair, if I may.
Yeah, thank you, Hattie. Yeah, thank you.
Yeah, if I may.
I mean, there's only a certain amount of V we can do here.
Given the indication from Mr. Holland that he'll be relying on his written submissions, if you're minded to accept that, then what I would suggest is that we continue with the order within which this committee would ordinarily hear evidence and allow Mr. Dadds, as he has indicated, to ask any relevant questions and then follow through the process. And if at any point the parties indicate again that they're relying on their written submissions, as you've already confirmed, you and your colleagues have had full consideration of both the agenda papers and the written representations that were received on Friday, and we'll proceed in that way. So if Mr. Dadds wants to at this point make his representations, or indeed, sorry, ask questions of
Mr. Holland. Well, Mr. Holland will to go again, I would imagine.
It rather looks that way.
Yeah.
I'm sorry if Mr. Dadds thinks I'm being extraordinary, but call me old-fashioned, but I rather thought that when somebody put in some written submissions, they were to give an indication of what the issues in the case were. Mr. Dadds obviously doesn't take that approach. And
No, Mr. Chairman, look, the papers are that Mr. Holland has put in is what he's put in. I've read them. If that's his submission and he says you've read them, he need not read them out because we've all read them.
Well,
but what I won't accept is that I can't challenge that evidence, or I've not challenged. I don't accept that I'm not challenging, or you've not heard my oral submission on behalf of the premises, and which I'm entitled to do today at this hearing.
Well, if I could proceed, I'm certainly not going to be reading out my written submissions, nor indeed reading out any evidence, because we'll be here for several days if we have to go through that. I'm assuming that the committee has read the evidence, has watched the body cam footage, and has read my submissions. There is only, I mean,
Hang on a second. We appear to be at an impasse here. Okay.
I'm going
I'm not entirely sure what, as a chairman, I can do. We have read the papers.
Yeah.
Okay. No. Well, I've read the papers, and so I'm not addressing you, Mr. Holland. I'm not addressing Mr. Dadds particularly. I'm addressing the body of the panel. What do we want to do here now? We've got the papers. What I would suggest to Mr. Dadds, and Mr. Dadds will correct me if he thinks it's untoward, what part of the documents does he wish to challenge, perhaps?
Well, Mr. Chairman, with the greatest respect, and I do say that, we follow the procedure. And I do. I mean, Mr. Holland needs to present his case, close his case. Sorry, I do apologise. I'm just responding to you.
Yeah. Thank you.
If Mr. Holland closes his case, and then you call me, and then that's my turn. We're not in an impasse. It's because I think Mr. Holland wants me to tell him now what I agree, what I disagree with. Well, that's not how it works. He makes his submissions, whether he relies on the submissions that were made last time, which I have no objection, we all had and heard, and we've got the papers. But he closes his submission, then you turn to me for me to make mine. That's it. Okay. And I will choose to how I present my case on behalf of the client at that time.
That's helpful. Thank you.
Chair, I'm just going to rattle through it. In opening, I adopt my written submissions that I submitted on Friday. The only thing that has changed since Friday the 13th is we still haven't seen the CCTV evidence. Other than that, it is all in my opening. The evidence on which I rely in this case is contained in your bundle, plus the video evidence for which people have been given passwords to watch. The statements of Constable McLaughlin and Omar Sabai are tendered in writing without the makers being made available for cross-examination. We did not anticipate that they would be required for cross-examination because no criticism to date has been made of the contents of those statements. If I see Mr. Dadds is shaking his head, he can make some submissions if he requires us to now go and find those officers and get them and bring them to this hearing so he can criticise what is essentially a narrative of what is recorded on body cam footage. But there are the written statements of Jamie McLaughlin and Omar Sabai, and then we have PC Brown available, and I'm going to call her to give evidence now. PC Brown, Penny Brown, can you switch on your camera? And good morning. Could you state your full name, please?
Yeah, PC Penelope Brown, 3267WA is my shoulder number from the Metropolitan Police attached to the licensing team.
And do you have in front of you a bundle of documents for this hearing, a 92-page bundle?
I do indeed.
just have a look, please. Excuse me 1 second. I'll just cancel that. If you have a look at page 32 of the bundle.
Yes.
There's an application there for a summary license review that's signed by yourself, dated the 21st of October 2020. Is that an application you made?
Yes, I did.
There's then at page 46 a witness statement signed by you, dated the 20th of October 2020.
Yes, that's correct.
And then there is an update statement at page 29 and 30, dated 4th of November. Did you make that statement?
Yes, I did.
Are the contents of those two statements correct and true, given that the second one updates the first, and so the first needs to be read having regard to the updates in the second?
Yes, that's right.
Chair, that's the applicant's evidence.
Many thanks, Mr. Holland. Mr. Dadds.
Yes, with your permission, could I ask some questions, please?
Thank you, please.
Yeah, obviously it's not for cross-examination. Obviously, we don't do that here. It's just points of clarification.
Yeah.
So, Mr. Holland, I don't know who is going to answer the questions on your client's behalf, or if you're going to answer it, which I'm quite happy for, of course. In relation to the graduated approach that's been submitted, can you tell me what steps were taken in relation to the September matter, i.e. from the licensing department, whether they put that in writing of any concerns or issues they may have? As you've seen, there is the Stand Directorate's route map that suggests that if there is a problem identified, there's normally a meeting of the representatives, normally licensing authority or the police service meeting, that they would keep notes, records, and keep a written notes. Normally a warning would be given, share information, agree the concerns and agree action plan, and possibly even do an action plan. Can you just, who is going to answer what steps were taken after the visit on the 30th of September, please? Sorry, Mr. Holland,
I need to unmute. Mr. Dadds, there's evidence in the papers at page 53 of an oral warning being given. Oh, that's the second incident. Bear with me 1 second. The papers speak of a warning being given at the first engagement. So far as I'm aware, but I'm going to ask Constable Brown, I'm not aware of anything more formal being done. Can you help, Constable Brown?
Yes, thank you. I can confirm that PC David Bracey, his body-worn footage of the first event will reflect that they were given a verbal warning about the offence, the incident that was happening on the first occasion.
PC Brown, could I just, Mr. Holland, it's completely up to you. If I can, obviously I'll direct it to you, Mr. Holland, you can go as you wish, but it may be from PC Brown. Can you, in relation to that oral warning, I understand that was about getting people out before 10 o'clock, is that right?
I'd have to re-go through the full footage to know the full depth of the conversation, but they were told obviously about the 10 o'clock closure and about the limit, where obviously Miss Cook confirmed that she already knew that there was a limit of 15 people. When she confirmed, she said at the time she had 3 floors, 45 people, but as you know, there was more than 45 when police returned later on. So it's to do with the numbers and the curfew.
And from the licensing authorities, the licensing department's point of view, looking at the Police Standards Directorate route map, you're aware of the route map, aren't you, in your department?
Yes, I've seen the submission that you've made, the paperwork that you've included.
Thank you for confirming that. Obviously, with Ealing, normally they would the licensing officers would meet with the representatives of the premises and go through a more of a formal process, whereas that there'll be a note taken and maybe a letter written saying these are the steps that are concerns we have and the steps that we agree that you will take going forward. And possibly you even do action plans, don't you?
We have done those things, yes.
Yeah. But here there's no letter, there was no meeting, no letters, no warning in writing, and certainly no action plan.
No, obviously on this occasion, the police officers, they may not be licensing officers, but they were still, however, police officers, were present on the evening and engaged with the people there and then in person. So we felt that conversation had been had, and we hadn't followed up with any other meetings after that at that time.
Is it fair to say that and it's acknowledged that there was a discussion, warning, I'll use that word for the moment, warning in relation to the officers on the ground, but in relation to that, was that past the licensing? Were the licensing department aware of that discussion? Was it kept on your innkeeper or whatever records that you keep?
It's generally done by email. I would have to go through to see how we were informed about it. At the time, I wasn't monitoring Ealing's offences, so it's Ealing's incident, so I wouldn't have been party to all of the updates at that time. But obviously, the licensing team were made aware. But I can dig into it to find out the exact date that they were told, if that assists.
Well, as long as I know that they were made aware, and I think you can perhaps agree with me, being made aware. I think what you're saying, not to put words in your own mouth, but what I understand you're saying is that it's accepted that the oral warning given at the time in September was sufficient. No further steps were required at that stage in relation to the graduated approach to enforcement. My understanding was that if there were, that they had given that warning, and if there wasn't going to be any further breaches, then we were happy going forward. Okay. Mr. Chairman, I just want to, I think that's the questions at the moment for PC Brown, but I wondered if I can go back to Mr. Holland and just ask some questions about the cam body footage, if possible. I can't hear you, I'm afraid. Yeah, okay. So Mr. Holland, if I can,
go ahead.
Just a couple of points of clarification at the moment. Do we know? Do we know whether the footage? So, for example, at page 76, which is the sort of part of the printout of the CAD, could I ask you just turn up to that for a moment, please?
'76.
Yes, it's at the top. I think it just starts with 1813. Can you see?
Yes.
Well, I wondered if one of your officers can just clarify. I've tried to work it out if I can, but is the body cam time right, or is it wrong by an hour? Is it out by an hour?
I think it's on GMT, Mr. Dadson. I think that's in a witness statement.
The reason I say it's that there's no surprises. It's just that there's a comment here, 1827, about approximately 150 people hostile will not be leaving. Well, the premises were virtually clear by that, and the inspector had made comments outside just past 6 o'clock. So I'm wondering whether the footage is wrong, because I went to the footage at that time and there's nothing there at all. And I thought, well, I wonder if that is an hour out.
Did you have any CCTV to support that, Mr. Dads?
No, I just was watching the footage. So obviously I thought I would go to 1827, and 1827, they've left, they're outside. He doesn't go beyond that time.
Yeah.
So, Mr. Chairman, that's why I'm asking, because I think the timing's wrong.
Can PC Brown switch her camera and her voice back on? Now these, yes, it's page 48, Mr. Dads, in the bundle. First full paragraph. The camera times are 1 hour behind because, as I understand it, PC Brown, they work on GMT.
That's correct, yes. So therefore they appear an hour out for half of the year. So yeah, I have made reference to it as Mr. Holland's pointed out there within the statement.
Right.
And then the reason is the GMT.
So okay. So as I say,
now, Mr. Dads, whilst I was looking for that, you were talking, and because I'm male, I can't multitask. Does that answer the rest of your query?
It just clarifies it, because obviously in my submissions later on, I can then make reference to it, because I've looked at the footage. Obviously, this note isn't the PC, I assume. It says a reference, but I don't know who.
PC Brown, can you help us with what the document is?
No, if I could ask a question, PC Brown, you can see the entry at 27 minutes past 6. It's reference. Yes. So that's 27 minutes past 5, I assume, yes?
No, so on the log that you're looking at, this incident call log, this incident log will be the correct times. It's only the body-worn footage, the times on the actual camera footage that's out by 1 hour. It's the film, the cameras themselves that are 1 hour out.
Right, I see. So so therefore, this is being recorded at 1827, and the footage that when we look at is an hour behind.
Correct.
Right, okay. So if I look at the footage at 1527, I should be able to look at this comment about 150 hostile. Yes, I should be able to see 150 people being hostile. Yes.
At 1727.
Yes.
That would be on the body worn.
Yeah. And who is H2647? Is that an officer?
My understanding is that will be the call receipt operator, the call handler. So that is being put on by a person at a computer that's not boots on the ground, so to speak. Where you see, for example, further down at 1837, you've got the little arrow pointing up and the number 3894WA. That officer is a 3894WA. They are an officer, and they are giving an update over the radio, and then someone at the computer is writing these things down. So all this, the text that you read is input by someone at a computer based on what they hear over the radio or what they hear via phone calls.
Okay, so can we just say, can we identify who's the officer 3894WA? Do you know?
I can have a look for you now. I can
thank you.
Look that up. That officer is PC Jamie McLaughlin.
Thank you. One moment, please. Thank you. The and obviously that officer's not here, I understand, today.
That's correct. He has provided a statement from when he was present on the 13th of October, but he hasn't been requested to appear here today.
Sorry, he hasn't been requested. Who was supposed to request him? Sorry, officer.
If he was going to be necessary, I don't believe there's any challenges to his evidence. His shift. He's not on this morning.
Right, I see. So he wasn't asked to attend by Mr. Holland.
Well, that's
or whoever instructs.
I'm not sure that Mr. Dadds can start cross-examining a witness about discussions between the police and their legal advisor.
Well, Mr. Chairman, I won't do that.
But if I can finish my sentence, we didn't call Mr. McLaughlin and Mr. Spy because there was no impression given in Mr. Dadds' lengthy written submissions that their attendance was required.
So I will make that in submission, Mr. Chairman, about who was called and why, what they were not called.
If you wish me to ask him to dial in, I'm sure I can do so. He can be hopefully within the next few minutes if you do require him.
Well, the thing is, I do have a question for him. Yes, of course I do, because there's a witness statement here. I expected a witness to be present for their statement.
Chair, shall we see if we can get the officer?
Yeah, it would be useful. We can try. Obviously, we don't know where the officer is or on what duty he's on.
He started at 11 o'clock this morning, so
you whatever you can achieve. Is it? But obviously, can we? Do we need to wait for him now, or can we move on to some more substance?
Yes, we can. I think we could move on if that's all right with you.
Thank you.
And then we can go back to that later if he dials in. Yeah, but I will. Obviously, I'll make submissions about the criticism that I'm receiving about not giving notice. I don't think it's right for me to make that comment now. I'll do it at the time, but I'll reserve the point that I will come back to that criticism, which I think is wrong, and I'll deal with that at the time when I'm entitled to speak.
There'll be no part of the police's case in asking you what to do with these premises will involve criticising Mr. Dadds.
So, Mr. Chairman, in relation to the police's evidence, in relation to, I think PC Brown is just making a call. So, should we just pause for a minute? Because I think I probably need to ask some questions.
Should we take?
I'm just sending the email to him now. If I need to call, I'll switch off my video again.
Okay.
Could I just ask you a question, PC Brown? In relation to the matter on the 13th of October, obviously you went for a summary review. There was no, was there any consideration about following the route map and calling a meeting to share information on your concerns by the licensing department?
After obviously they'd already done the first breach with a large number of people past the hour, and Miss Cook having been spoken to on that occasion and being well aware of what those breaches were, the fact that another breach that was so blatant and so soon after the first one, and as officers commented in their statements and on the footage, that it was, in their opinion, the worst they'd seen. In our opinion, the only thing that we could do really was to try and get them closed as soon as possible to stop this happening. That, at the end of the day, that's all we wanted to do, to stop these breaches continuing, and this seemed to be the best route to do so.
Are you aware that there is the health and safety, you can issue a prohibition notice, or police can issue a closure notice?
I have heard about the closure notice, yes.
And you didn't consider that was perhaps a more appropriate step to, as you said, close the premises as soon as possible?
As I said, we wanted
to stop the breaches.
To stop the breaches. Yeah, we didn't want this happening again, and so this seemed the best way. They seemed to be acting in an irresponsible way. They weren't upholding the licensing objectives, so we felt we had to take action. We
So
felt
you're saying
it would have been irresponsible not to have done so.
So are you saying that you did consider issuing a closure notice or look at the prohibition notice?
So you know, there seems to be a Socratic method going on here, but the license and objectives have been mentioned here, and that is the matter for the panel. So perhaps you know, PC Smart could respond to those specific things in terms of licensing objectives. Would that be helpful to you, Mr. Dadds, given we are a licensing subcommittee?
No, Mr. Chairman. The reason for that is because I'm just understanding the graduated approach to enforcement is to look at all the tools available. My question was, had you considered a prohibition notice? Had you considered a closure notice? The answer, and I've got the answer to that, is no, because they thought the best way forward was to issue the section 53, i.e. the expedited review, because they wanted to close the premises as soon as possible to prevent the breach. So that's what I'm just understanding the different tools that were open to them about proportionality, because it's right for me to make submissions later on about proportionality and appropriateness.
Could I just interject with a point of information in that the police don't have powers to issue prohibition notices under the Health and Safety at Work Act legislation.
Yes, that's why I issued talked about closure.
I know you suggested it was an arrow in our quiver, so to speak.
It is, but I'll explain later in my submissions. So, Mr. Chairman, when you said about asking the other officer about licensing objectives, I'm just going through about process at the moment, about the steps. So I'm not being disrespectful. That's why I said no.
Okay.
I at this stage, I have no further questions. I would like to ask the question of the officer, but perhaps we could have a short adjournment, see if that officer is available. If not, that's all I ask of points of clarification, because I'm not allowed to cross-examine. Points of clarification from the officers.
Okay, just give Councillor Constable Brown an opportunity. You know, she's probably on the phone at the moment, so let's see where she is.
Thank you. I have emailed the officer, and I've just emailed another officer on my behalf to make a phone call if possible to PC McLaughlin online.
Mr. Chairman, it's so that it's all clear. All I'm going to ask the officer, so we can deal with it later when he dials in, is that obviously there's a record here of the it's saying it's hostile, and I've looked at the footage, and that doesn't correspond to what I'm seeing on the footage. So I'm asking to explain what he means by hostile, and that's it. So that everyone knows in advance that's
yeah. It's you're looking for him to expand on that word, so to speak.
Because I'm going to be critical or bringing that out, and I'd at least give the officer an opportunity to comment on it rather than me just make submissions. Okay.
So, Constable Brown can mention that to him if she managed to speak to him before he dials in.
I don't think she needs to mention to him, because I'll ask him the question directly. But that I'm just letting you know why I'm asking, so everyone knows.
Thank you.
Obviously, I don't want to put words in the officer's mouth, but having seen the footage and seen the conversations between the officers, I believe it was more the fear of the crowd turning hostile because they were so greatly outnumbered, because of obviously there was a lot of people there, and there was the fear of the hostility, which is why there were so many officers that were turning up, because they were trying to prevent any disorder, any further disorder taking place.
But I'm conscious about putting words into. Let's see what the officer says, because I've got a written record. It doesn't say.
Okay. Right, let's. So hopefully it'll be put to bed once the officer comes. So, yeah. But yeah, in the absence of nothing else to talk about. I guess we're trying to fill the gap, which we don't need to. Anything else, Mr. Dadds?
No, just really that to ask that question of the officer, and then that's all the questions I have in relation to the police.
Okay.
Obviously,
right.
I want to make submissions, but I'll do that at the appropriate time.
Yeah, I'm just putting a call into the officer now.
Yeah,
Kerry.
that'd be great. Yeah, thank you. If we could track down the police constable, that would be useful. I'm going to turn my camera off just for the few moments, but I have my earpiece, so I can hear everything.
Hello, Chair. It's Kerry.
Yeah, sorry, I was just unmuting. Yeah, go ahead, Kerry.
Cornelia, if someone, the officer, I've got hold of the officer, if he just dials in on one of those numbers with the meeting ID and the passcode, will he just gain access? Can you just confirm that?
I'm sorry, Penny, could you repeat that, please?
So I've got the officer on the other line. If he just dials in on one of the numbers that you've sent through with the meeting ID and the passcode, he'll be given access. Is that correct?
Yes, he will. Yes, because the other PC ending with the phone number ending 106, I saw him when he entered the meeting room. Just make sure you give him the details for the main hearing and not for the decision hearing, because I sent 2 emails out and they've got 2 different passcodes. So it's the one for the main hearing, not the decision hearing.
It's the passcode 958.
Cornelia, thank you. He's just dialing in now, and I'll get Penny to forward his statement to him. So he's just dialing in.
PC Jamie McLaughlin.
Join the meeting.
Thank you very much, Officer McLaughlin, for joining us. Maybe Mr. Holland or Mr. Smart may want just to introduce you before Mr. Dadds has some questions.
Yes, Chair, I will just remind Mr. McLaughlin what this is about. Constable, can you remember making a statement in relation to a premises in Southall called the Tudor Rose?
I can. I currently don't have it in front of me, but I did make a statement.
We can't have it being called Southall.
Southall, yeah, sorry. Southall. I'm terribly sorry, Chair.
That's all right.
Not my neck of the woods.
No.
And I thought I knew I was going to get it wrong, and I thought I'd get it spectacularly wrong for you.
Okay, go. Tudor Rose, Southall. Yeah.
Yeah. Now, the officer hasn't got his statement in front of him. It's not a very long statement. Would you like me to read it out so he knows what's in it?
I'm not going to challenge the statement. It's just the record on the CAD that I'm looking at.
Let's read it out, please, Mr.
Right.
Holland.
Okay. Yeah. So this is your statement, Constable. I'm a serving Metropolitan Police officer currently attached to Southall Police Station. Got that right. Where I work as a dedicated ward officer on Southall Broadway Safe Neighbourhood Team. The incident took place at Tudor Rose, 68 The Green, Southall, UB2 4BG, which is a musical and event entertainment venue, on Tuesday, the 13th of October, 2020 at approximately 18:20 hours. I was on duty on the Green Southall UB2 in police uniform. I was with my colleagues PC Wilkinson, PC Spy, PC Tween, and PC Riaz in a marked police minibus. We were responding to calls of an illegal rave at Tudor Rose on CAD 5817/13 Oct 20. When I arrived at the venue, I could see lots of people dressed up smartly loitering outside Tudor Rose. These males and females appeared to be dressed as if they were attending a wedding. Officers spoke to the security at the rear entrance of the venue, and they confirmed that there were about 150 people in the venue from the travelling community for a wedding. I entered through the main door to the venue, made my way into the function room with my colleagues. I immediately saw that there were about 150 people in the function room, ranging from young children to men and women in their 60s. Everyone was stood on the dance floor area of the function room, dancing together, kissing and hugging. There were also people ordering alcohol from the bar, which was open. It appeared that there was no table service happening and that the guests and the organisers of the event were not complying with COVID regulations. There was no social distancing taking place, and no masks or protective gloves were being worn by the majority of the staff and none of the guests. It also appeared that there were inadequate supplies of hand sanitizer available for staff and guests to use. It was clear to me that none of the staff were encouraging the wedding party to socially distance or leave the venue. The breach of COVID regulations was, in my professional opinion, the most flagrant breach I have encountered since the COVID pandemic started, and I was shocked by what I saw. The risk to public health was grave, and none of the wedding party or staff seemed to care or be actively trying to avert this risk. PC Spy spoke to the owner of the venue, who admitted she had organised the event. I updated the control room with the numbers at the venue and awaited the arrival of Duty Inspector Wills. When Inspector Wills arrived at the venue, I briefed him and entered the venue with him at about 1840 hours. I activated my body-worn video camera. When I did this, I exhibit my footage of this incident. Inspector Wills spoke to the father of the bride and informed him that only 15 people could remain in the venue and that everyone else had to leave. With the assistance of security staff, the venue was cleared and 15 members of the wedding party remained. I then left the scene. That's your statement, Constable.
Yeah,
is that true and accurate?
It is, yeah.
There may be some questions now from Mr. Dads, who is the advocate for the venue at this review hearing, which we're currently doing.
Okay.
Hello, officer. I've just got a couple of questions of you, if you don't mind.
Yeah.
Thank you for ringing in so on short notice.
That's all right.
There was a on the Chris and Cad printout. There's a record at 23 minutes past 6 on that evening, on the 13th of October. It says, attendant, we've got a hostile reception. We'll need a unit or two. So that's one comment. And can you just explain what you mean? Because I've watched the body cam footage. I know you weren't the officer that was wearing the body cam footage that was being disclosed. But what do you mean by hostile, please, there?
It was when I referred to my statement, when we went to the back entrance and spoke to security, there was males drinking outside, and one of these males said to me, officer, you're going to have a very difficult time if you try and break this up.
But he wasn't hostile.
That's what I mean by hostile.
Okay,
so it inferred that we'd find it difficult and we'd be met with resistance if we went in and tried to break it up.
But he wasn't hostile to you.
The crowd was hostile because they basically said if we tried to break it up, we'd be met with resistance or assaulted. Is what I took from what he said.
Well, you said crowd. You said one gentleman spoke to you and said, if you go in to try to stop that, you're going to.
No. There was a group of males drinking outside by the security guard.
Right. Okay. And then but they weren't hostile. You perceived that it would be hostile if you went in to break it up. Is that what you're saying?
Well, I perceived him to be hostile towards us because he's actively told me that we're going to be met with resistance should we go in and try and break it up.
Yeah, that one male. Now, in going on, 3 minutes later, 1827, it says approximately 150 hostile will not be leaving. What did you mean by that?
Well, we were told by numerous individuals, if you try and move us, we won't leave.
So that's what you meant by hostile?
Yeah, that was whilst we were in the venue.
Yes, because I've looked at just to let you know, officer, I've looked at the footage and I don't see any hostility in it. So that's why I wanted to understand.
Yeah, this was prior to when I activated my body worn, because I activated my body worn at 1840, as per my statement. So this was 13 minutes before that. So that's why it's not recorded in my statement.
Yes, and so you didn't feel threatened enough to, in effect, put your body cam on. You left that for another 14 minutes.
Well, I waited, as I've said, I waited the arrival of the duty inspector who would be coordinating the event. I then, after I'd briefed him, I then activated my body worn, as we may have to take enforcement action.
Yes, and Inspector Wills said on the at the end, because I don't know if you're the officer who asked for the section 35.
No, that wasn't myself.
Yeah, so it says, I've got no antisocial behaviour. This is what the inspector says. Actually, they have all been pretty good. And so at the moment, I'm not prepared to do a 35 because at the moment, they are actually all behaving themselves and I've had no grief at all. Now, do you accept those words of your inspector? Is that what you found?
Well, that's his opinion. I found them to be hostile when we went in because Inspector Wills wasn't present before that. He only turned up just before 1840, so I could brief him. So he didn't experience the hostility that we experienced.
But that hostility that you're talking about is on the body cam footage that we can all watch, yes?
I don't know whose body camera footage that has been disclosed in this hearing.
But your body cam, so obviously in case this goes to an appeal, you've got your body cam and that will show the hostility that you had when you activated your body cam.
Well, my body camera footage, as I've said, was 1840, and that was when myself and Mr. Wills went in, and when the individuals inside had significantly calmed down and we were able to have a dialogue with them. So this was prior to my body-worn camera being activated. Significantly
calmed down? Please tell me what you mean by that, because that's a very emotive language. We've seen the footage of the...
Sorry, just 1 second.
Sorry, that's a very emotive language, officer.
Chair, firstly, significantly calmed down isn't emotive language. It's just plain language.
Well, the officer can answer that.
Can I finish? It's plain English. And
no, the officer can answer that.
I can justify these comments if you wish.
Witness
exactly, officer.
Rules
you don't need the defence of your Mr. Holland.
Chair,
and I'm asking a question. You could stop me if you thought I was out.
Can I interject, please, gentlemen? Mr. Adds, the officer uses the word hostile. It's an interpretation of the conversations he initially had with the people outside. He believes that any enforcement would be met with hostility. Is that fair to say, officer?
That's correct, yeah.
Yeah, okay. So, you know, I think we're going into the weeds with this word hostile. It's a single word in a long statement.
And Mr. Chairman, I was going back on when he says significantly calmed down. I said that's emotive language, I believe.
So he said it was less hostile then. So
no,
I think
he say less hostile.
Less hostile.
Calmed down. So I was just asking the officer I was just about to ask the officer if he could explain what he meant by that, because it can be misinterpreted. So language is very important here. Because we've seen.
I'm objecting to this because significantly calmed down is neither emotive nor complicated.
To be honest, I've got one question for the officer. I just want him to tell me how many people he believed was in the venue at given times. But I don't really need to ask him because I have it. I have that information. But maybe he'd like to expand or just confirm how many people he saw himself with his own eyes at the venue. Whether they were hostile or not is not really something I'm giving that much consideration to under the license and objectives. It's whether how many people are in the venue under COVID regulations. So how many people are in the venue, officer, to the best of your
as I've stated, yeah, I believe it's immaterial the way they're acting, but it's between 100 and 150.
Okay, well that's useful. So Mr. Dadds, obviously you want to pick up on the language the officer used at different times. Go ahead.
Mr. Chairman, if I could just make
Yeah.
a quick observation. Look, I think I've got what you've said. You've said, well, look, I want to know about the numbers. If the numbers are there, that's all I want to know about the breach. And in effect, how they behaved is not relevant in your understanding at the moment because of in relation to licensing objectives. But if it's accepted that their behaviour doesn't undermine the licensing objectives of crime disorder, not antisocial in that way, then if the committee have accepted that, then I don't need to go through and challenge that. I say that they weren't acting contrary to what Inspector Will says. So, and if that's accepted, then that's fine, and I don't challenge it.
Well, I don't. It's not that I don't accept it. It's just that an interpretation of a word at the start and the end it isn't going to change that, surely. You know. I mean, yeah.
Well, I can't assume what's in your mind, and that's why I have to because I know that I had counsellor.
The hostility is relevant. The hostility is relevant. Of course it is. Of course it is. But the officer has said at that time they were hostile at the start. So maybe could Mr. Holland allow what he believed was the hostility later on?
And so, officer, you said that they significantly calmed down. Can you just explain what you mean by that, please?
I think it was we were able to then have a dialogue with the father of the bride, which we weren't able to have initially because we had tried to engage with the crowd initially, and it fell on deaf ears. Basically, they wouldn't engage. So by the time we'd gone in with Mr. Wills, because they were informed that he was the duty inspector coordinating the incident. I believe we were able to engage with them better.
But that was the first time that you had actually engaged with the father. Is that right?
With the father specifically, it was Mr. Wills, Inspector Wills, primarily spoke to the father.
Yes, but was that the first time you spoken to the father?
To the father, it was, yes.
Yes. So therefore, he hadn't significantly calmed down because that was the first time you spoke to him, and it's fair to say on the footage, he's calm, isn't he?
Yeah, when I spoke to the father, he was calm, yeah.
And in fact, I think he was very polite to the inspector, showed courtesy, didn't he?
Yeah, I wouldn't disagree with that.
Okay, look, I have no further questions, Mr. Chairman, of this officer.
Thank you, Mr. Dadds. Thank you. Mr. Holland, do you want to say anything in response, sir?
Chair, do you or any of your committee members have any questions for the constable?
No, I asked my question of him, but Councillor Ahmed or Councillor Sumner. Councillor Sumner has indicated. Please unmute your mic, sir.
Chairman, thanks very much. Can I ask David Dadds, Mr. Dadds, have you seen the CCTV then that we haven't yet seen and has been requested?
So this is the question, Mr. Summer. I've seen the footage.
Sorry.
I've seen the same footage you have on the body cam. So I'm challenging what the officer was saying because of the body cam footage. Obviously, this is
to ask you, Mr. Dadds, whether you have seen the CCTV from the premises.
No, I haven't. I will be making submissions on that later. But in relation to this matter, I am referring to the footage the police have provided and what's on the written record that show a contradiction. So that's why I asked the question.
Okay. I'm sorry to correct you on my name. It's Sumner. Okay.
Yeah, I always thought it was that, but I was going by what the officer introduced you originally this morning. Yeah. So I thought I must have misunderstood.
No, thank you, Mr. Dadds.
We do have a Councillor Sumner on the council, so and a Councillor Summers. Councillor Ahmed, do you have any questions for the? Well, it was for the officer actually, Mr. McLaughlin.
No, Chair, I don't have any question.
No. Okay, fine.
Could I ask that the officer essentially be released from the hearing so he can carry on with his other duties this morning?
Yes, please. Thank you very much, Mr. McLaughlin, for coming to us.
You're welcome. Take care.
Thank you.
Bye-bye.
Thank you.
Chair, well, that's the evidence for the applicant.
Okay, thank you. Mr. Dadds, would you to respond?
Yes. Members, you've seen my written submission. It builds on the submission that I made before you in the interim steps hearing. Can I just ask if you've had an opportunity to read it?
Yes, we have.
Yes.
I have.
Thank you.
Correct.
Thank you. I'm going to obviously deal with a number of issues this morning. Firstly, of course, it is clear that I, on behalf of the premise licence holder, challenge the police service in relation to the certificate and the definition of seriousness. I don't do that challenge here because the proper place for that is by way of judicial review. And you've seen the first pre-action protocol letter and the additional pre-action protocol letter, which is in effect a response, but an improved position, because obviously we have to act, as you realise, relatively quickly on an expedited review application. You only get very short notice. So there has been a second letter that's gone out to not only the police service, to the local authority and to the Secretary of State for Health. I say that that the police have got the legal definition of serious crime wrong. But in relation to that certificate, as I've said, that's not for you. That is not for you to consider today. But what you can consider, obviously, is you'll look at whether there has actually been serious crime. And we'll go through that because I know that Councillor Ahmed and ourselves had discussions about that last time. The facts of the case I'm going to go through and look at what occurred on the first occasion and the second occasion and make some comment in relation to the police's representations and statements. What I'm going to be saying, Mr. Chairman, is that the police are asking for revocation, and I say that's disproportionate. You, following your own guidance, look at the causes of concern and only do what is necessary and proportionate to achieve, in effect, the licensing objectives. This is not, as you know, and we all know, this is not about punishment. It's about achieving the licensing objectives. You know already through the papers that a civil penalty has been issued and that the matter has now been resolved in relation to the COVID-19 breaches. So in other words, the police have elected to issue a civil penalty for £1,000, and that is how they are dealing with the breach of the regulations. I don't know what's happened with Councillor Ahmed. The screen's gone funny, but so in relation, is he still there? I don't know.
Councillor Ahmed, Munir, are you there? May have just. Munir?
I think he's coming back. Could you ask him again, Mr. Chairman? Sorry.
Yeah. Munir, Councillor Ahmed.
If he obviously leaves, I ought to be told so I can pause for a moment.
Yeah. I think we'll pause.
Yeah.
Cornelia, or do you mind to give Councillor Ahmed's mobile a call?
Okay, Councillor Kelly, I'll do that.
I can see something wiggling just there.
Thank you. I'll try and call.
He's
Okay.
right. He's back. He's back. Councillor, Mr. Dadds, go ahead. Councillor Dadds, in fact, still. Yes, go ahead.
Yes. I don't know. I don't know where Councillor Ahmed has actually heard the submission. Where did you? I don't know where you got up to, Councillor.
Minir, can you just?
Yeah, my camera was actually stuck, and I think I lost. If you can go 2 minutes before.
Okay. Well, I know roughly where the camera went, so that's why I stopped.
Thank you.
Yeah.
So the premises has been issued with a penalty notice. It's been amended from the £1,000 to £10,000 to £1,000. But I think the point I make is that a civil penalty has been issued to deal with the breaches of the COVID regulations, Mr. Chairman. So that is obviously how the police are.
Would you just mind confirming who that has been issued to?
Yes, that's been issued to Mrs. Cook, as I understand it. We haven't received a copy, but I understand it's been issued to Mrs. Cook.
Okay.
The
licensee. So.
Yeah, well, yes. Well, she's not the licensee. The licensee is the company, but as I understand it, they've issued it to her.
Okay.
I think you're one of your councillors is indicate councillor.
Yeah. Chair, sorry to interrupt. Mr. Dadds, I thought I heard you say civil penalty had been changed to £4,000 before there was a gap. Can you just confirm what is the amount that's actually been that you're referring to?
Sorry, I said £1,000. It was 10, and it's been amended to 1,000 now.
Well, I wrote down 4, so that was my excuse for coming back. Okay, thank you.
Thank you. So the penalty has been issued. Now, so there is an acceptance because obviously we can't challenge the certificate here, and we can't challenge the lawfulness of the regulations here, although you've seen my submissions. On face value, as it is now today, because the regulations are in force, and there is a breach of the COVID regulations. That's accepted. It's as clear as day in relation to there are more than 15 people on the premises, Mr. Chairman. So in relation to whether I think there's some dispute on numbers, but there's been 70 from one officer, 100, 150. It goes from a vast number, but I can tell you what the numbers are. We say there are approximately 70 people on the premises. Now I will come back to that about why we can't be clear on that number, but I'll explain in a moment. But coming back. So the public notice was advertised, and you'll be aware there are no other parties joining the review. There's no environmental health. There's no licensing authority, so that your own licensing authority has not joined the review. No other councillors locally, and no residents have joined the review. And you will look at the track record. I mean, since this license has been granted, there's been no other matters arising. I mean, there's been other licenses and those are historical, but this license has been granted. And since it's been granted, as I understand it, there's been no no other matters arising in relation to the activities. There should be a graduated approach to enforcement. And what I've said is that, as you see, that there is the problem licensed premises route map, which I sent to everyone. And normally, what you would do is identify the starting process. As you look at the, can you look at the route map for me, councillors? You'll see that the normal process would be to identify the problem, assign the ownership, who's going to deal with it. So that's when I talked about earlier on that you could issue a prohibition notice, you could a closure notice, you could call them in for review and do an action plan. But here you can assign it. So if, for example, you wanted a prohibition notice for the premises to close, you could ask Environmental Health or you could ask the responsible authority at the council for health to issue a prohibition notice, and that would be the end of it. It would be the premises would have to close, and that would get what the officer's comments were, that close as soon as possible. Yeah, and so that's why I'm saying that I raised that as a point earlier. Also, the police could issue a closure notice, which gives the premises normally 7 days or a number of days to which to comply with the breaches of the Licensing Act or any matters which they see fit relevant to the operation of the premises. But you see here on the route map, it says, then meet with the representatives. So you'd meet with them. You make a written record, notes of the meeting, and notes of, in effect, the outcome. So you share information, the concerns, and agree what the problems are, and then develop an action plan. And then obviously an action plan will be implemented. Councillors, you're all aware that if there are problems on a licensed premises, there's a graduated approach to deal with that. You don't go from having concerns where the officer says, well, we gave words of advice, they gave a warning in September, and no additional steps, she said, were required because they were happy going forward. So they were happy going forward that warning was enough, no further steps were required at that stage. So normally there isn't, you would perhaps say you can't have weddings, 15 on each floor, or you can't have anyone over 30 at that time and then now 15. And those are the words of advice that you would see, and it would be documented, in my opinion. But in any event, at the time, that was the gravity of it. As of end of September, they would be happy going forward with just giving an oral warning. That was the position at the end of September. And you and I know that if there are problem premises, whether there's a GBH, assaults, crime accumulating, there will be a build up to work with the premises, try to get compliance with the route map or with the council, it's the regulator's compliance code, get compliance, and only when that fails do you then seek a review, a standard review ordinarily, and an expedited review is only when there is serious crime. Without a shadow of a doubt, you've seen my legal submission, and you're entitled to form a view on not the certificate, but on the facts that there is not serious crime, that this does not meet the threshold of serious crime. I know that Councillor Ahmed and I had a discussion last time that this is serious, but there is a difference between the definition under this piece of legislation of what serious crime is, and that is defined quite specifically, and you see that in my legal argument, and serious crime that is still serious that it's breached. So I know we're using the same word serious, and we were talking about the word hostility earlier on, but so it is serious, and I'm not taking away the point of there's been a breach, and that is serious on the facts that here and the regulations that as they are today. But that doesn't mean it meets the threshold of serious crime where that someone would receive 3 years in prison. That they wouldn't. This has been dealt with by a civil penalty of £1,000. That's it. So I'm not trying to take away, councillors, the point of this is serious. We've got to discuss it. We've got to get compliance. We've got to go forward, and licensing objectives got to be met. I understand that, but let's not say that this is akin to guns, knife, serious crime disorders defined by that piece of legislation, which I've set out in my submission. So coming back to the route map, you would see, if it was so serious and there'd been a lot of matters going on, you would see that there would be an action plan. There would have been a sit down and meetings, unless there was clearly a shooting or something like that, or something very serious that immediate action is required because it's met the test of serious crime under the legislation, where that someone over 21 years of age of previous good character would receive over 3 years. That would be that trigger event. But we're on the main review now, so I'm trying to deal with those matters which are arising. So you would look at the cause or causes of concern and do no more than that is necessary and appropriate. So it's about proportionality. And I know that you will be, I know I've dealt with a number of councillors before, and you will take a proportionate approach. There has, in relation to the sanction that the police asked for, it's a permanent one. It's a complete revocation. And that can't be proportionate to what we're dealing with here, which is the breach of the COVID regulations, which is serious, but you wouldn't make a permanent revocation. I mean, it's been suspended. Everyone's on lockdown anyway, and you do have a number of powers available to you. You do have the ability to suspend the license up to 3 months. You have sanctions to remove a DPS and put other conditions on in place. And I'm saying that there is much more a proportionate response to this serious breach of the regulations, but not serious crime as defined under the Act. So that's the difference. I hope you understand what I'm saying. In relation to the incident or the matter of September, you will know by reading the papers that, in fact, the police had been called by a member of the public just after 10 o'clock in the evening, and the police were in attendance. So the police did attend, and they spoke to the Mrs. Cook, and she had spoken to the officer and said, look, the bar's closed at 9:30. There is no music. The party, it was a traveller community wedding. The party were still sitting at their tables, and some were refusing to leave. But she said, there's no more music, there's no more alcohol, there's no more business carrying on from that point of view. And I don't believe in my submission that that is a breach of the regulations, because there's no sale of alcohol, there's no sale of food. People are being asked to leave. Now, I said this before, when you are a community hall, or if you're a place, if you don't fit into that category, there's no breach. Even if I set that aside and we accept that this is akin to a pub or something similar, then the rules are not clear about people being out at that time. It's about service. But in any event, the officer knew that they didn't come into the premise. They knew, we said that there were about 30 people in the premises, and we still believe that that is roughly the number, not 52. And we had explained how we had segregated 15 from one party, 15 to another room, 15 to another, and plus children. And the officer said, okay, well, obviously the security are there. Obviously get them on their way. My understanding is that there are still a number of individuals there, in excess of around about 30 people there, not leaving just before midnight. And my client had asked the security to move them on, but the security were ineffective insofar as they weren't asking them to leave. They were trying to get them to leave on their own accord. the police turned up. There were four officers, I understand, and then the gentleman left, and gradually, and they left. So that is the highest it was. It wasn't that we were trading after 10 o'clock. It wasn't that we were just not complying with the rules, insofar as we knew that we had to be out by 10. Obviously, I'll explain the position in relation to the numbers in a moment, but certainly that is the highest it was in September. And my client has given me those instructions to make that oral submission for you of the account of what happened in September. But there was no further interaction at that stage from the licensing authority, from licensing, nor was there any further steps taken by the licensing police. So there wasn't, as I say, when you look at the route map, no further steps were taken. And you've heard the live evidence that from the officer today, that they were happy going forward with that warning would be enough. Then we move on to the matter of the 13th of October. Now, this was a wedding party for the travelling community in this party. It was to be divided. The booking was to divide different rooms within the building to have 15 in each room for their sit-down meal. It was maximum of 45 adults plus children. My client accepts that she misunderstood the regulations, thinking that children were not to be in the count, and there were 30 plus children. The booking was for 30 children, 45 adults. So in total, there would be no more than 75 in the whole building. She had said that they were all due to sit down and have their meal by 5 o'clock, but in fact they didn't turn up. Sorry, they was due to turn up about 4 o'clock, ready to have their meal at 5 o'clock. But in fact, they started to turn up about 10 past 5, and the numbers coming in did not represent the numbers that she had taken the booking. She told security to stop any more coming in to the building just before the police arrived, so that she could have a chat to the party to say, look, you're supposed to be in separate areas for your food, and that the numbers should be as the booking. Then the police arrived, and she acknowledged that he had got out of hand, insofar as what she means get out of hand, and it's the same point, Mr. Chairman, about the word hostile. Her interpretation of getting out of hand was the numbers, because as she told the officer, I'd booked 15 on different rooms, plus children, and that those were the numbers that she expected. The numbers that turned up were not the numbers that she had booked before, notwithstanding that she would have got it wrong in relation to the regulations of children, and certainly wrong in relation to her interpretation of being able to put them in one room for the dinner, 15 in another, 15 in another, to divide it. You and I know, councillors, that the premises that operate, whether it be a community hall, premises like us doing weddings, pubs, restaurants, they're all having a very hard time, and that they are trying to interpret the rules as best as they can to try to keep open, trading, people employed. And that interpretation that she has made in relation to the 15 is clearly wrong, and in relation to children, wrong. But it's not through some malice. It's her interpretation of trying to get the business and keep the business surviving, because we all know that this community space is used by various elements of the community. It's the traveller community, Black Afro-Caribbean community. A number of people use it, and it has great value. And I know that Councillor Kelly, you and I, we talked about the letter from the leader, recognising its importance and its value to the community. Now, in relation to that night, the police then turned up, and you've got the body cam footage, and there are discussions. I would respectfully submit that there is no antisocial behaviour or anything that would meet the threshold of saying that the licensing objective of crime disorder is undermined. And in fact, one of the police officers on the body cam at roughly 18:02 says the security are doing a pretty decent job. And there was, as you've heard from Inspector Wills, he made it quite clear in his submission, or sorry, in his comments at the end of the body cam, and I'll repeat it again. He says, I've got no antisocial behaviour. Actually, they're all being pretty good. And so at the moment, I'm not prepared to do a 35 because all at the moment, they're actually all behaving themselves and I've had no grief at all. And the reality of it is that within, as soon as the police arrived, and by approximately 10 past 6, the premises is cleared. The only people remaining was 15 people, which was the inspector agreed that it could continue the wedding, but only with 15. So the premises, they arrived quite late. As soon as they start arriving, we close the door because the numbers are not right. The police then arrive, just happened to, that a call had been made. And then discussions were had with a voluntary closure. And in fact, that is exactly what happened. The steps were taken to, in effect, say that this is not going to continue and people must leave. And then it was, in effect, negotiated, I think, by the father of the bride and Inspector Wills that actually it could continue, but only with 15. And that, I mean, there was some negotiation because I think Inspector Wills, you know, with respect, said it should be 30. Then he was reminded actually it's changed from 30 to 15. And there was some negotiation, horse trading, sort of to try to get a higher number. But the father of the bride was very polite and showed respect to the inspector. And I think you can see that in the footage. There is no and should be no criticism made of the traveller community or the members of the public that were there, because with the great respect, there were lots of comments made by officers through the body cam, but actually when you look at actually the conduct and behaviour, certainly what we see on the evidence on the body camera with the audio, that no one was, in my submission, causing antisocial behaviour or a public order offence or anything that would undermine the licensing objectives. I know that Councillor Ahmed mentioned about the ladies at the end talking about, you know, we've got down to 15 now, I want you to leave, and he thought that they were being rude. But I don't think that that would amount to a public order offence or an undermining licensing objectives in a matter of opinion and judgment. But in relation to the duration, that's the steps that took place that day. So ensuring that there was a booking. The booking should have been 15, 15 plus the children, and it was over. We do not accept that that there was service directly from the bar. There were drinks dispensed from the bar with trays to tables, and because it had already been pre-purchased. But I think whether it's pre-purchased or not, I don't think really, Councillor Kelly, that's going to really amount to much today. The point is that alcohol was there. I think this is all about numbers and the breaches of the regulations and what is an appropriate and proportionate response from the licensing authority's point of view in relation to the licensing objectives, because the police, from the crime sort of approach, they've issued the civil penalty. I would ask from the licensing subcommittee no more than a suspension, no more than a 3-month suspension. And in relation to security, as I say, I think the police thought that they did a pretty good job. Our client believes that they should have limited the numbers on the door to the numbers of the booking, but that got out of hand, and that, you know, if you felt that the security needed to be removed, we would agree to that, but we don't think perhaps that is the way forward. In relation to the risk assessment, you've heard, a risk assessment has been updated. That's not for the police. Mr. Holland and I think agree on this. It's not for the police to assess the risk assessment, nor the committee, because the police are not the competent authority, and the Health and Safety, Environmental Health didn't make comments to this review. But I can say that the updated risk assessment has been sent to the council's Environmental Health and Safety, and that's been sent prior to the hearing, so that they've got that. So if there was a period of suspension, whether it be a month, 2 months or 3 months, ultimately the premises wouldn't be open, and that will give time for that risk assessment to be agreed, if need be, from Environmental Health. If they felt that that didn't meet the criteria of the COVID regulations, they have the prohibition notices to issue if they felt that that was an appropriate and proportionate response to the risk assessment. In relation to the DPS, obviously you could remove the DPS, and we would have to seek to get a new DPS if you felt that the DPS fell below the standards required. In relation to the CCTV, it's relatively straightforward, and I know that Councillor Sunna has mentioned this. The CCTV has not been provided yet. I understand the CCTV has or is being downloaded. I on Friday was aware that this issue in writing has still not been resolved. So over the weekend, I'd had 2 discussions with my client about trying to get the CCTV to the police ASAP. Because the premises is closed, and because of the lockdown, there is no one at the premises. So the email sent to the premises, to the email address there, hasn't been picked up, I'm afraid. And my client has not received a voice message. Now, that may be left on the answering machine at the premises. But CCTV is in operation, CCTV is there, and my client is getting it downloaded so that that can be given to the police service. But members, can I say, the CCTV, I don't think helps helps anyone any further than we already know. We know we're over on the numbers, and we accept that. We know we're not serving at the bar, so we'll provide that. But in any event, I don't think that is relevant here to your determination of the breach of the COVID regulations. And I understand the condition of the licenses to give the CCTV to the police, and you could say that there is a breach. But the request, I've been on the record. I know that it was raised last time, but I thought it had been resolved. But obviously, I could have been written to, and I could have chased it up a bit sooner if I knew that it was still outstanding. But I didn't realise that. Obviously, I'm trying to assist, but I don't think that in itself should be seen as something which would warrant a revocation, even with the regulations. The CCTV is being sorted as we speak. As I say, I don't think it adds anything further. So just to wind up on my submission, is that it's accepted that there's a breach of the regulations as they stand today, and they're enforcing law. That you've been given an explanation of what happened on the September and what happened in October. I ask you to take a proportionate approach to what steps you can take today, and not impose an ineffective permanent sanction of revocation. It's about proportionality. and you've heard about the fixed penalty. And also bear in mind, there's been no neighbour complaints. Look at the track record. And since this licence has been granted, the licensing authority, I think, would be duty bound to intervene if they felt that licensing, your own licensing officers felt that they should join. And in addition, no residents have raised any objections either. I don't believe there was any crime disorder on the night other than, as the facts of the law now, as the breach of the COVID regulations, but no other crime disorder was occurring. And that the matter that was occurring is not serious crime, serious instance of a breach of the COVID, but not serious enough to warrant a revocation of this licence. Going forward, obviously my client will have to comply with the regulations as a matter of law. They have retained me for me to give them advice of what those regulations are so that they can keep up to date. They've completed their risk assessment sent to the Health and Safety Department. Other than that, it is them having a full understanding of the regulations and complying those regulations going forward. Unless I can assist you any further, I'll just ask my client if there's anything further that she wants me to add. Will you just bear with me one moment?
Maybe I want to ask a question, and you may have to refer to your client. So
yes, so I'll just double check that on the submission at the moment.
Okay. Yeah.
My client was just, I think she says that I've made the point, but I'll make it clear again. She's saying, look, there was no serious crime disorder. People were, in her opinion, being well mannered. And in fact, she believes that the police wouldn't have allowed the wedding to continue if that was the case. If there was hostility, if there was that, then it wouldn't have continued with the 15 being allowed to stay on. And they stayed on until I believe it was 9:30, 10 o'clock. So she just wanted to make sure that that was clear to you, Mr. Chairman. So if you've got any questions for me, if you ask, and then I can ask her those questions.
Sort of two questions. Obviously, first question is the rooms of 15. What was the mechanism by which your client communicated that to the patrons on the night? You know, how did she communicate that to them?
Yes.
And also, the CCTV would be very useful and relevant, but my question specifically is because in the absence of it is how were the drinks dispensed on that night? What was the, you know, were people coming to the bar? Or were, you know, if you could just remind me what the client done on that night.
Okay, I'll just pause
for
a
wedding.
Yes, thank you. I'll just pause for a moment. Thank you.
I understand. Thank you. Just Councillor Sumner, Councillor Munir, do you have any questions just to get you ready?
Yes, I will come on mic for a second.
Okay, cheers. Councillor Sumner.
No, thank you, Chair.
Thank you.
Mr. Chairman, the in relation to the rooms, there's a separate entrance into the different rooms, but there's only one exit out, and that it was obviously communicated that they should be in their separate rooms, go to the separate rooms. But as I understand, so just on that point, that's why there were 6 security, because ordinarily you wouldn't need that amount of security, but she employed that security to keep that those guests are in that room. And that's why she said she put a hold on the door to actually go and sort it out, to find out, to put people in the different rooms, because they were waiting. She says the food was already ready, should have gone out by 5, and they were turning up late, and they were waiting to serve the food. They wanted to get people sat in different rooms. But what she said was that
how was it communicated beforehand? But before the event, what was the anticipation? Yeah,
it was communicated in the booking. How? Yeah, my understanding, it was communicated in writing with the booking, and it was booking was done in advance with the father. And
do we have that? Do we have that writing?
I believe. Do we have that in writing? Yeah, they have a contract, so that's in writing. Okay. The other issue is that what went wrong, as I understand it, and this did go wrong, and it's accepted, that they were when they all arrived, they all wanted to take photographs. So in fact, on the dance floor, they weren't dancing on the dance floor. They were all on the dance floor because they were trying to take group photographs of all the parties. And that's where it went wrong, we say. And we accept that. In relation to the second question of the dispensing of the drinks, it was table service. My client says that they do get up to go to the bar. Only 2 of the shutters are up because obviously that's where the services come from. But there's a security at the bar saying, no, you can't be served. You have to be served at the table. So it was drinks brought to the table. So that is how service was done, like the food. So unless I can assist you further, Mr. Chairman, they're the answers.
No, it just might have been useful to, obviously, with necessary redactions for
well,
privacy,
can I just see if I can? Let me just see if I can sort that. One moment.
Yeah.
Mr. Chairman, because of the lockdown, my client is not in the building, but the contract is in the building. If it became necessary, we could try to get that to you. I don't know how quick it could be, but we could be scanned over and sent to you. But if requested, if needed.
Okay, thank you. Councillor Ahmed, you indicated.
Yes, it's not a question. Mr. Dad, thank you for keeping me on board. I had a glitch on the IT. This is the first time we are using this Zoom as meeting. We usually use a different software, but thanks for that. You specifically addressed me on explaining the seriousness of the crime, and I fully get that. I fully get that the difference in these two seriousness of the crimes, and I thank you for that. No further questions, Chair.
Thank you, Councillor.
Sorry, yeah. Mr. Holland's, I believe it's you now, and obviously Mr. Dad's, I don't believe he would have right of reply. So is there any questions you have for Mr. Dad's initially, Mr. Holland?
No, I'm not. Don't think you're going to be assisted by lawyers asking each other questions. I'm going to deal with this.
Well, that's
submission.
I dare say. Thank you. So, Mr. Holland, if you could make final remarks.
Mr. Chairman, can I just clarify? Sorry, Mr. Holland.
Yeah.
In relation to where we are now, is that closing submissions?
I believe.
I understand I go last on closing submissions, since we're the we're the premise license holder and have the most to lose. Normally we go last.
My understanding it's the other way round, but Hattie is probably
the one that's got the most to lose goes last.
But the person putting the review in goes. They're the applicant, aren't they? So I'll take
if it helps,
a steer from Hattie.
If it helps, I've got no.
It would be
Hattie, if you could help, please.
Yes, Mr. Holland I have suggested that I think it's him going first, and then Mr. Dadds will be giving his remarks at the end.
Okay, thank you. Let's go ahead, Mr. Holland.
Chair, just a bit first on the law. It's very easy in expedited reviews to lose sight of the fact that there's two things for you to do today. You've firstly got to consider what steps to be taken in relation to the application. So what, if any, of the steps in section 53C are appropriate, and then it is necessary to review the interim steps and decide, because the interim steps lapse as of this hearing, and it's necessary to decide whether there should be further steps pending the decision coming into effect, because your decision doesn't come into effect until 21 days, or if there's an appeal, until the appeal's been disposed of. So I just flag that at the beginning, because it's quite easy to forget that there are two tasks for a licensing committee in this position to deal with. And my submissions are that the license should be revoked, and further that it should be that if you agree with me and that it is revoked, that the license should be suspended pending that decision coming into effect. And what I'm about to say relates to those two issues you've got to deal with. And I'm just underlining that because not cases I've been involved in, but I'm aware of a couple where recently where that's gone wrong. So far as the licensing framework is concerned, Chair, I've dealt with this in my written submissions at paragraphs 14 through to 28 at pages 8 to 10, but just a couple of things I'd like to underline orally. Your task is to consider the application, any relevant representations, well, there haven't been, but what Mr. Dadds has to say, and looking at that in the whole, then take such of the specified steps as you consider appropriate for the promotion of the licensing objectives. And that includes the steps are listed, modifying conditions, removing licensable activities, removing the DPS, suspending the license for up to 3 months, or revocation. And as you've already heard, the police's position is that the appropriate step is revocation. Although the word in the Act used to be necessary, what was necessary for the promotion of the licensing objectives, and it's been changed from necessary to appropriate, I'm not going to I accept that it has to be proportionate, and proportionate, basically you need to be satisfied that no less a step will do than the step you are taking. There is guidance provided by the Secretary of State under section 182 of the Act, in paragraphs 11.16 to 11.28. And the points I just want to underline is this is a forward-looking exercise. I agree with Mr. Dadds that we're not here to punish anybody. We are here to look forward as to how to promote the licensing objectives for your community going forward. What the guidance says is if a previous stepped approach has been attempted and has failed to address concerns, you shouldn't merely repeat that approach. You need to take into account the previous failure of a stepped approach when considering what further action is appropriate. The core test is that licensing authorities should, so far as possible, seek to establish the cause or causes of the concerns that the representations identify. The remedial action taken should generally be directed at these causes and should always be no more than an appropriate and proportionate response to address the causes of concern that instigated the review. There's a word missing in my submissions at paragraph 25 when I say the section 182 guidance recognises that is a proper consideration. The missing word is deterrence. Deterrence is a proper consideration. You can look at, in cases involving crime, one relevant matter is whether it is necessary, it is appropriate, and it is proportionate to do something to deter the license holder from future offences and to deter the trade generally from future offences. Now, in fact, I am not putting too much weight on deterrence here because the police's position is that the package you have been presented with by the respondent to this review raises significant concerns that the cause of the problems has not been identified and dealt with. I'm not saying deterrence is irrelevant, but it is not the core part of this application. You must exercise your powers in the wider public interest. This isn't the police versus the premises license holder. It's not an adversarial competition where one of us wins and one of us loses. This is for the wider public interests of the inhabitants of your area. It's a matter that you have to make for the wider public interest. And in relation to that, I've just listed a shopping list of wider duties, paragraphs 29 through to 34 of my skeleton, because as a local authority, as I'm sure you're very aware, you have a raft of statutory duties imposed upon you, and they include a duty to exercise your functions with due regard of the need to do all that you can do reasonably to prevent crime and disorder, including antisocial and other behaviour adversely affecting the local environment in your area. You have a duty, or the council has a duty to take such steps as it considers appropriate for improving the health of people in its area. The regulator's code says that regulatory activity should be targeted at cases where it is needed. You're subject to the Human Rights Act and the Public Sector Equality Duty. And that, I think, is the point where I segue, Chair, into the facts here and make some admissions. We accept that this is a valuable resource for the community of Southall. We accept that it's particularly valuable for BAME inhabitants of the council's area. We do not rely on any incidents predating the two weddings that form the subject matter of this review. And we certainly accept that revocation is a step you should only take if you consider that no lesser step will do. there has been now a belated acceptance, but an acceptance nonetheless of breaches of the regulations in relation, I think, to the second incident. It's accepted that it is a serious breach or a serious matter in the Anglo-Saxon use of that word rather than the definition one finds in REPA 2000. I think it's accepted that you needn't trouble yourself with the jurisdictional challenges that are for another day and another dollar, so far as Mr. Dadds is concerned. And really the focus that I would invite you to bring to this is the two incidents, and in particular, given the occurrence of the first incident, the repetition of the same problem less than a fortnight later is a matter that I think you need to give a lot of thought to, as to how it's bad enough once, but how could this have happened twice? Given what occurred on the first occasion, without some sort of recognition that there's been a failure of management, there's been a failure of risk assessment. The premises has essentially walked into the same situation it had to be rescued from by the police in relation to the first incident. That's the factual scenario on which the review is based. And then what evidence is there, what material is there before you that you can be satisfied this isn't going to happen again? And one of the, it's been suggested that a lesser step might be suspension. Well, suspension is all well and good, but suspension needs to be allied or coupled with some sort of change. You can't suspend for the sake of it, just because it's less bad than revocation. There needs to be some purpose to it. And the theme throughout this application has been a failure on the part of the venue to really present you with any compelling plan as to how they're going to put their house in order, how the premises are going to be put in order. The first incident, yes, Mr. Dadds is right, that the first call came from a member of the public, but the second call came from the venue. And it came from the venue because the venue had lost control of the premises. It could not get the guests out, and notwithstanding the security team, who were doubtless doing their best, and 8 of them, they could not clear the venue, and the police had to be called. The police had to be called at 1 minute to midnight, when there was a 10 p.m. curfew in place. And when the police arrived, they found 52 wedding guests inside the venue. You have seen the CCTV. They were considerably, some of those individuals were extremely drunk. Many of those individuals were clutching open vessels containing lager and beer, and I think there's what looks like Guinness at 1:20 in the morning, still being held by customers as they're leaving the venue. You are told that the bar closed at 9:30 p.m. It would have been nice to see the CCTV to confirm that. But we don't have the CCTV to confirm that. And really, I'm not sure what more the police in this review could have done than underline in my last set of written submissions that provision of CCTV was a condition of the license and it had not been complied with. Repeat that at the hearing. No response to that, so further communications are sent. I mean, apparently an email can't be received because the venue isn't closed. That seems a rather That seems a rather mid-90s approach to emails rather than the way it all pings through onto our smartphones now. But even giving the premises, the venue, the benefit of the doubt, I was asking yet again for CCTV yesterday on Friday. Here we are on Monday. It's still not been provided. Now, this is a really important matter. This licensing committee can't sit on the shoulders of every person it licenses to sell the drug of alcohol in connection with regulated entertainment 24 hours a day. There has to be a certain amount of trust that people are not abusing the privilege that's been given to them. But one way of checking is a CCTV condition, that there be CCTV, that it be recorded and it be provided with, and that's in place here. And it's extraordinary in my submission that here we still are, an expedited review in place, as Mr. Dadd says, quite a lot for his client to lose, a request being made repeatedly, and a request not being complied with. Now, Chair, an oral warning was given in relation to the first incident. You may think that the premises was extremely lucky to have effectively been dealt with so lightly in relation to that, when, if you've watched like I have, the 47 minutes of police officers patiently, with good humour, attempting to clear out 50 people who simply decided the simplest way to deal with that for most of that period was to simply ignore the police. You may think that is a rather low level of regulatory intervention and a display towards the premises of an appreciation of the difficulty it had with a wedding group that simply wasn't going to listen to anything anybody told it, but to then voluntarily sign up for the same thing a fortnight later is extraordinary. And I mean, it's only, I think, through good fortune, perhaps, that the police were called as early as they were called, because I can't see really any distinguishing feature between wedding 1 and wedding 2 in terms of its makeup. And that is, again, for the avoidance of any doubt, no comment whatsoever on the nature of the those who had booked, but what one saw in incident 1, that at 10 o'clock the venue did not think it had a problem, and by midnight the venue said, we have got so sufficient a problem that the police need to be called. I think it's eminently predictable that eminently likely that the same process would have gone through in relation to the second event. But the key thing is this: at the second event, an equal loss of control. We have 15 plus 15 plus 15. We have a wrong reading of the regulations. I think when one is running an event with the potential to cause the public health problems that it's taking, I don't think it's excusable to get the regulations wrong. You should have been taking professional advice if you couldn't read them yourself. I don't think it's a matter of any great debate that the rules on gatherings include children. Everybody, I would suggest, knew that. But even taking the venue's explanation at its highest, giving them the benefit of every piece of doubt we can possibly give them, what Miss Cook said to the officers when they arrived was that she tried to keep them separately, and I'm paraphrasing here, but you couldn't stop them dancing together. And the venue on the second occasion had lost control in the early evening, had lost control of the risk management plan it had in place. We hear drinks dispensed from trays to tables. Again, wouldn't it be nice if we had the CCTV to check that, but we don't. I, of course, accept that risk assessment is a subject that involves a certain amount of expertise. The Management of Health and Safety at Work Act regulations of 1999 speak of competent person, a competent person who has to get involved in the drafting of this. This is a police review, but it's a review heard by the licensing authority, and I think it's unfortunate that we don't have the risk assessment in front of us. I think it's unfortunate that if there are any management policies and procedures here for the safe operation of a venue, they're not in front of you either. We don't know how roles are allocated within the venue and who they're divided up against. And in fact, we have very little in terms of positive evidence from this applicant, from this respondent, on which you can be satisfied that it can proactively promote the licensing objectives going forward. The vast amount of legal firepower here has been devoted at a judicial review that's got nothing to do with this committee. There's extremely little material in my submission that you can be satisfied that the premises can promote the licensing objectives going forward. And as I said in opening this morning, I think we are very little further forward than where we were on the 23rd of October. There hasn't really been any substantial challenge to the facts on which the police rely upon. There's a dispute about whether individuals were hostile or not at a particular point in time. There's a complaint that we could have taken a different stepped approach. Well, that's really irrelevant now because it's in your hands, and you're not an inspector of constabulary. And that's about it. We are no further forward in my submission than when we were on the 23rd of October. And for those reasons, I ask you to revoke the license. Now, before I finish talking, we're obviously in different rooms and indeed in different parts of the country. I'm just going to check with my clients if I've missed anything out and skim through my notes. Anybody got anything to say? Hold now.
No, we're happy with that, Charles.
All right. Okay. Well, there you have it from my client direct. Those, unless there's anything I can particularly help you with further, those are my submissions.
Thank you very much. Councillor Sumner or Councillor Ahmed, any questions?
No questions from me, thank you, Chair.
No question, Chair.
Yeah, just quickly, I need to get a charger. One of my devices is about to die, so before Mr. Dad's go, I'm just going to grab a charger. Sorry about this.
I'm just going to pop outside the room, Mr. Dads, for a second, okay?
Yeah, we'll wait for everyone to come back in the room. One moment, please. I'm just waiting for Councillor Sumner, I believe. Okay. Thank you. Yeah, Councillor Sumner's back with us. Thank you very much for your patience, Mr. Dadds. Please.
Yes, no,
Thank you, Chair. We don't have built-in comfort breaks, unfortunately. But
are you ready for me to close? Right. So, I'll start with. Sorry, is Charles back? Just to double check. Sorry, Mr. Holland back.
I never went away, Mr. Dadds.
Thank you. Sorry, I didn't want to start just in case. I'll start with the point made by my learned friend that says it's not relevant now to look at whether the stepped approach was taken or not, because you're now grappling and dealing with it before us today. Well, I don't agree with that, because Mr. Holland wants it on one hand to argue that they took a graduated approach, and on the other hand saying it's not relevant today because I challenge that approach. It is clear, and I welcome the acceptance that prior to the matters in September and October, the police do not rely on any other matters. You heard that as their submission. In the certificate, it referred to other matters which were relating to another licence, not this licence, and would be inappropriate. But nevertheless, as a matter of fact and submission now agreed that there are no other matters predating these matters of September and October. The premises is a community valued asset. It adds value and is welcomed by the community, and that's accepted by the police. I think the leader of the council, and we believe that that is the case for the community. And I think that's borne out by the community. Not, you're right, Councillor Kelly, I just saw it whizzing around. You're right there, Councillor Kelly. Should I start again? Yeah. So on that bit, so there are no community, no other parties making representation, no residents, neighbours, councillors against this premises, and I think that is important, members, to have in mind. I always think that we should look at proportionality what is appropriate and proportionate. And I think to be appropriate and proportionate, I always use the term necessary, because if it wasn't necessary, you wouldn't do it. So, and the law is quite clear on that. Using the R and Minister of Agriculture, Fisheries and Food, it says this, and this is quite a useful point. By virtue of that principle, i.e. proportionality, the lawfulness of prohibiting of an economic activity is subject to the condition that a prohibited measure are appropriate and proportionate in order to achieve the objectives, legitimacy, purpose of the legislation in question. When there is a choice between several appropriate measures, recourse must be had to the least onerous, and the disadvantages caused must not be disproportionate to that aims pursued. So in other words, if you've got a number of choices, you obviously take the least onerous to actually achieve what you need to achieve. And that is obviously quite important here. And that's why I said, well, you've got a step of suspension, which is a lesser step than a permanent resolution, i.e. a sledgehammer to crack a nut. But let's go back a little bit more about the facts and just talk about proportionality. It has been accepted that there's been a breach of the regulations, and that it's serious in relation to those matters. But as my learned friend accepts that there is a challenge, and we know the difference between the definition of serious crime and disorder under this piece of legislation and our normal interpretation of what the word serious is. And I accept the Councillor Ahmed has read the papers and understood the difference that I was trying to make last time between those two things. And there is still a challenge that this trigger event, the certificate and what brings us here, was unlawful and not appropriate. But that's not for you to decide today. I'm not asking that. But that definition of breaching the regulations to say it's so serious, i.e. serious crime disorder under this definition, you've seen my written submission, is inappropriate. The first incident where my learned friend says we lost control, actually, no, we didn't lose control of ourselves. And in essence, there was no antisocial behaviour or no arrest, no public order. The police obviously came along the first time and saw and was satisfied to leave at 10:20, saying that we, music off, bar closed, leaving us to try to get them to leave gradual with the security. It's because the people were in effect not moving. I think my learner friend said that was to the effect that they wouldn't even listen to the police. So these members of this group, this party, this wedding, didn't listen to our security and were reluctant to listen to the police, but they did, and they left. My learned friend says, well, they should be happy that they were dealt with lightly on that occasion. Well, actually, they were dealt with appropriately. They were given words of advice, a warning, and the police then, on that basis, thought that was the end of the matter. Going forward, they were happy. That the reality of it is, if they felt that it warranted more action, then they take it at that time. And in fact, it could be argued that if they said at that time, look, you can't have weddings in this order like this, you've got the rules wrong, then I would respectfully submit the next event would not have occurred, because they would have then understood the regulations. My friend says he'll give us the benefit of the doubt, or give them the benefit of the doubt potentially if you want to, at the highest. But they should, he says, they got it wrong, but they should have got professional advice. It was inexcusable that they got the regulations wrong. But you all heard on the CCTV that the inspector got the rules wrong too. He said, no, you can have 30. You can have 30. And he said several times, and a couple of the other officers were saying, well, he's got that wrong. You heard it. So the thing is, the interpretation of the rules have been difficult. There have been so many and so many amendments that members of the public, including the police, are struggling to keep up to date with them. And that is evidence here. So the benefit of doubt should be given to the premise licence holder. And I don't accept that it was, he says they have to be rescued. And I think that's a motive language again. What they did was responsible. You and I know, we've had it before where you say, well, why didn't you call the police when an incident happens and it escalates? And there's criticism the police weren't called. And this occasion, there's no actual disorder. They just don't want to leave. And the law says, well, you can be asked by a constable to leave. And it's responsible to ring the police and say, look, I've had these people here. You already know you've been here earlier on. We've been trying to manage it. They've not left. They won't leave. Can you assist? That's appropriate. You wouldn't say that would lead to some other further action. I think it sat where it was, no further. I do take exception. I don't understand what was said. And I think my learned friend started to hesitate slightly, but I'll put it like this. To say that even though that this happened, this community traveller wedding, they proceeded to sign up 2 weeks later to another one. Yeah, given what's gone on, nothing's changed. Hang on a minute. That's suggesting that, oh, you've had one traveller wedding, you couldn't manage it, and you then signed another traveller wedding, grouping everyone together. That's no different to say you had a wedding by black people and you had another wedding for black people 2 weeks later. Completely inappropriate. They are different people. And in any event, it's not like, I'll wait for Councillor Swimmer. So I'll just pause for a moment. Are you all right, Councillor Sumner?
Councillor Sumner, are you with us? Yeah, he's with us.
Sorry. So the issue is that this idea that we're being criticised for signing up voluntarily, he said, signing up again for another traveller wedding. Well, I'm sorry, that's inappropriate. And the thing is, this idea of signing up voluntary to have it again, have what again? What, a wedding? Yes, we had another wedding. It's by different members of the traveller community. It wasn't signing up afterwards. It'd already been pre-booked. We had it pre-booked. We had the numbers, we had the security, and we obviously were proceeding on that basis. So this idea that because a traveller community wedding went wrong, that we should, in effect, discriminate against all traveller weddings in the future? Or is my learned friend saying that one wedding went wrong, it shouldn't happen again? Or what additional steps you put in place? But you've heard, prior to the September incident, we hadn't had any other matters like that occurring before. That's the first time that we'd had to call, as I understand it, on the evidence, and certainly from my instructions, first time we had to call. So it never occurred before, and no suggestion that it would occur going forward. And it's completely two separate matters. These the other party was about overcapacity and breaches of the regulations, not about people refusing to leave. So, in fact, people did leave voluntarily, and they regrouped themselves to select only 15, and it was all dealt with. And as you heard, and I've repeated multiple times, the inspector said no antisocial behaviour. They're pretty good. At the moment, I'm not prepared to do anything, because at the moment they are all actually all behaving themselves, and I've got no grief at all. I think he went on, if I'm right, to say this was the best gypsy wedding he'd ever been to, in a sense of order. Maybe you could, councillors, just look at that recording, because you can't group one group of travelling community with another and say, well, because they behaved, you shouldn't have signed up voluntarily to another. Now, in relation to the October, 13th, you've heard what was said. Yes, my learned friend says that the CCTV was really important, a really important matter, but I'd never been approached saying, as the acting solicitors for the company, I didn't receive any email. I weren't asked for any of that on behalf of the company. But in any event, I think the point being at the time, my learned friend was mentioning it, is that it would have been nice to see that the bar was closed and the music was off. But the officers were in attendance at the time, and we told them that the no sound, no music. Obviously, they'd been served to the tables and they were drinking up what was served on the tables in my respectful submission. But going forward, councillors, so that you can be sure of no matters like this again, because this is what it's all about, is so that we cannot undermine the licensing objectives going forward. Whilst there's any COVID regulations, and you can make it a condition, Councillor Kelly, during the restrictions, there'll only be one wedding at a time in the whole premises. So therefore, there cannot be these multiple groups. Only one wedding be allowed during the COVID regulations, and that obviously that number will be restricted by the regulations at the given time, whether that be 15 and after lockdown if there's a change, or any change in the new year. So only one wedding, so that going forward there will not be a repetition of multiple rooms being used. And the risk assessment, he's absolutely right. The police are not the body to comment upon that. That's the health and safety, environmental health. That has been sent to them. They are not party to these proceedings. They have not joined as a responsible authority, I believe they would be duty bound if they felt that they needed to join. They haven't. And they have their separate powers to deal with any matters arising in the future if they're not happy or comfortable with the risk assessment that has been submitted. In relation to the stepped approach, I do say it should be a stepped approach. There's case law that sets out. So my learned friend, on his statement on the 13th of October, lists the number of breaches within the regulations. There is a case where we've called Glastonbury festivals, where it says if there's multiple offences, it still only creates one breach. So the one offence. So in other words, you can't give a £1,000 penalty for, say, over 100 people, 1,000 because they're mixed, 1,000 because they're standing and hugging, 1,000 because there was no table service, for example. You can't do it. It's that one event, that one occasion. It's accepted that it's breached and there's one offence. That one offence has been dealt with by the police service with one fixed penalty for £1,000. So it has been dealt with in relation to where the police put it as the seriousness. They're not prosecuting. They put a civil penalty. That's how they're dealing with it. I made those submissions. It wasn't challenged. That's the position. And that from the Licensing Act point of view is that, okay, what do we do going forward? How do you look at the cause or causes of the concern and only do what is appropriate and proportionate steps going forward to address that concern? And I say the concern was the weddings, concern was regarding knowledge of the regulations, and on that basis you've heard from me that they're retaining me to give them advice on the regulations as they come out, and in relation to weddings they're going to restrict it to one. And looking at the track record, there's no matters before these occur. And so I believe that they should be given the benefit of doubt in relation to their interpretations. They should be dealt with by way of, because of the breaches, by way of a suspension. You have up to 3 months. That will be a proportionate and appropriate way going forward. And you heard already that the police are saying that they believe the security were doing a decent job. You've heard the police inspector talking about no antisocial behaviour. This is not a premises where there's been any public order, any offences by the public. This is a review because COVID-19 regulations have been breached on the second occasion, 13th. On the first occasion, I think it is questionable whether they have been breached because, one, there's no civil penalty. I don't believe there's any suggestion insofar as having people on the premises after 10, as long as there's no sale of alcohol and licensed activity, there's no breach. However, we are trying to move them out, and you've heard all my submissions in relation to that. So going forward, Mr. Chairman, I know that members will be concerned that, licensed trade, community halls, function halls, weddings, pubs, restaurants, they're all having a very hard time. No different to my client. It is about you're going to, in effect, not punish them, but you're going to give them a sanction. And I ask that you be proportionate in your response. Going forward, you can have confidence, I say, in that they're only going to have one wedding at a time. You can be confident there's no antisocial behaviour or crime or disorder by patrons. There's no evidence of that. And going forward, that licensing objectives can be promoted. This is simple on its fact that the COVID-19 regulations were breached, and that going forward, there won't be any misunderstanding or misinterpretation of those regulations, and that that they will promote the licensing objectives. And if nothing else, a period of suspension up to 3 months will focus their minds to ensure that there is no reoccurrence of this, and that you can then leave the premises in place in 3 months' time to operate. It is a community asset, it is valued, and we'd like to keep it there in place, promoting the licensing objectives. In relation to what my learned friend said about you have 2 tasks, that's correct. If you are with him on relation to revocation, I accept that the interim steps would be modified to continue, in effect, the suspension. If you are with me in relation to a period of suspension, you'll amend the interim steps to set out a period of suspension from today for 3 months. So therefore, the suspension, in effect, is taking effect now. And notwithstanding your decision doesn't have effect for 21 days, it has the same result, so that the premises would be suspended for up to 3 months. And any other steps, like, for example, the condition that there should only be one wedding during the national pandemic, the regulations, and that any other measure, for example, you may remove the DPS, you'll put that on the interim steps too. So it's just to mirror your decision. Whatever you do today, normally you would mirror that by modifying the interim steps, so it has effect. I think that sort of just clarifies where we are on the interim steps. Unless I can assist you further, that is the closing submission. I will just actually ask my client, sorry, because they're normally sitting next to you. Let me just ask my client if there's anything else that needs to be said. I have nothing further to add, Mr. Chairman.
Thank you.
Chair.
Before we, yes, Mrs. Councillor Sumner, yes. Councillor Sumner, did you have something to say?
I have nothing to say. I don't know why you're picking on me, Chair.
I think
it was Mr. Holland who spoke.
Okay, I did beg your pardon, Mr. Holland.
Can I just beg your leave to come back on one specific point Mr. Dadds has made?
Only that he will have right to reply again to that matter. Fine, thank you.
He's made a very serious suggestion that it's some part of my submission or some part of the police's case that the heritage of the wedding guests is relevant. That was not my submission. It is not my submission. The submission was this, that the rule of 15 was in place for both these weddings. The venue's scheme to get more than 15 was to split it into groups of 15 plus 15 plus 15. That scheme ended in the police, and I reuse the word, having to rescue the venue from the consequences of that the first time around, and they did it again. The heritage of the wedding guests is a matter of utter irrelevance to that and is no part of the police submission. I shall say no more about the way Mr. Dad's characterised that to this committee, but for the avoidance of any doubt, it is the repeated holding of a single wedding that is artificially divided into different groups, and the expectation that they are somehow to be kept apart was the mistake that this venue made twice, and nothing to do with the heritage of the wedding guests.
Thank you.
And in reply to that, you heard what was said. I only heard what was said, and I responded appropriately. What I'd say in relation to the comments made is that that's just been made. They're two different events insofar as the first one was about people refusing to leave, and not in relation to, because there was only one exit, which was to be resolved by the additional doorman. But that was the first time that had occurred, and it was the words of signing up voluntarily again to another, in effect, another wedding 2 weeks down the road. He's now saying that what he meant by that is what he's just said. And what I would say is that the first occasion was first time occurrence, people, members of the public not wanting to leave. The second occurrence was in relation to not people wanting to leave. It's that the overcapacity and more people came than was booked. And they're totally distinct from that, not to be mingled between the two. But you've heard my submission. It's all about proportionality, and I ask that that be taken into account, and that revocation is not appropriate. Suspension at the highest would probably be.
Thank you, Mr. Dadds. We're going to retire now to consider the matter. Could I just, perhaps from Cornelia, there is a 2:30 hearing going on. So are we going to be able to come back before then, or has that been dealt with separately?
Actually, that's not for today. That's on Wednesday.
I beg your pardon. I'm mistaken. Sorry, we've got a heavy agenda. Yes, indeed, that is Wednesday. There is no further hearing. No, what it was, I just didn't want us to,
I had provisionally set up a decision hearing, I believe, for 4 o'clock. Let me just double check that for today, 4 o'clock.
That sounds ideal. Yes.
Is that?
Yes. Yeah.
Okay.
I think that would be right on time. Yeah.
So I'll come back at 4 o'clock. Is that right?
Thank you. Yeah, we reserve the right to take longer, but we're confident that we'll be here. We've made a decision by that time. Thank you very much.
Thank you very much, members.
Thank you up, ladies and gentlemen. Thank you.
Thank you.
Okay.
Thank you, Chair.
So I'm going to end the meeting now.
Yeah, thank you, Cornelia.